Today on Spot the Issues, we are going to discuss confidentiality agreements in commercial matters. I'm Emily Campbell from the Campbell firm. I'm a corporate attorney. I've been practicing law for over 2 decades, and we at the Campbell firm are very interested in promoting entrepreneurship and an understanding of key issues that are involved in a number of different business areas. Confidentiality is a key ingredient for a company that is trying to preserve its secrets, its proprietary information, and it needs to do that in a number of different contexts. In this particular segment, we're really going to talk about entering into NDAs or non-disclosure agreements and confidentiality agreements that are for transactions with other parties, not employees or independent contractors. We'll save that for another day. Excuse me. So basically, confidentiality has a number of different key elements to it. One is that you need to have protection for your confidential information, and this comes up in a number of different contexts because people often try to say, well, maybe I can only protect this information for 2 years or 5 years or 7 years or something like that. There certainly are times where confidential information might become what we call stale or otherwise expire, but in general, if a company is privately held, their information does not really become stale or somehow irrelevant to their business model. Particularly if they're showing in that confidential information a variety of different financial types of information, such as profit margin, cost of goods sold, etc., as well as if there are intellectual property considerations, so that some of the sharing may be related to ideas that otherwise would be patentable or would be subject to copyright or trademark protection. And sharing this type of information outside of a private conversation, which is very risky for companies, lends itself to the discussion of why you would need a confidentiality agreement or a non-disclosure agreement prior to entering into those type of discussions with another party. So those types of things might be if somebody was entering into a vendor arrangement with someone for them to provide certain types of services as a third-party provider. And I'm specifically not really talking about independent contractor relationships. Again, we'll talk about that in a different segment. But if somebody has to access your information, such as if you're on an AWS platform, your documents and things are going to be confidential, and that's subject to a variety of exclusions. And of course, that's part of what the confidentiality agreement would lay out, are exclusions. So, for example, there might be an exclusion for things like a regulatory or governmental investigation or litigation where there's a subpoena required to produce certain documents, where a party acquires that information without reference to the confidential information itself through some other channel where that information is not otherwise protected. A key element, of course, and this is part of what ties into something becoming stale, is if the company itself, who's providing the confidential information, decides to make that information public and put it into the public domain, or it becomes sort of a known industry type of situation, those would also be similar exceptions that you would see in many documents. And again, also the company certainly can consent at any time, whether it's stated in the agreement or otherwise is something that is done in writing and consenting to a disclosure. But absent those things, most privately held companies' confidential information does not simply become irrelevant to the world of their business just because the passage of time is occurring, right? So beware, if you are a company and someone is proposing that you only protect your information for 2 or 5 or 7 years, and that somehow then the information could be disclosed, there is sort of a difference between the length of the agreement itself, of how long this agreement might take place, and whether something is a surviving section that would allow protection to extend beyond the term of the agreement itself. For example, in most contracts where you have a payment, there's an obligation to perform, and the agreement may go on for a certain amount of time, but if for some reason the contract is terminated earlier, certain provisions might continue to apply. For example, confidentiality might continue to apply, or payment obligations if somehow they missed a payment. Just because I terminate doesn't mean that the last payments aren't due, right? So in the confidentiality arena, if you have an agreement that, let's say the agreement itself is for a 2-year period, but then after that, the agreement expires or somehow is earlier terminated by the parties because they agree to it, you would hopefully have in an expiration and termination section or surviving sections clause the fact that the confidentiality would continue indefinitely. Now, if you're entering into pre-litigation situations, there may be other considerations. You may have a particular recipient. You may also have some interested parties. Affiliates and representatives may need to be defined, because obviously every attorney and every accountant and every person working at a company isn't going to sign those documents, but hopefully they've signed something reasonably similar to those documents that you're entering into to protect for the same amount of time. But if you're really focused on trying to protect your information, particularly information that you consider to be trade secret, proprietary, something that is not industry known, that gives you a competitive advantage, it is really critical that you don't just say, well, of course, 2 years, that seems totally reasonable. Every situation is different. And, a public company, for example, if somebody entered into an agreement and they're going to disclose their financials in any way, I mean, in a large part, what difference would it make if, you had a 2-year confidentiality clause, that 2 years was the whole caboodle, right? I'm going to be keeping this information confidential if it's just financial, for example, or it's a particular plan that's actually got to be implemented. Like, hey, I'm launching a new product, and of course, I'm actually planning to do that. And the vendor relationship is actually like the branding company that's hired to facilitate that. But again, in a pre-litigation context, you have to remember that if you were going to court and were getting a protective order, for example, from a court for confidential, highly proprietary information, you would not be limited by time. It would be something that would be normally subject to being protected even after the litigation ended. So going into these arrangements on a private basis with simply the idea that, of course, hey, I'm only going to protect this for 2, 5, or 7 years, that's a mistake. And I see that a lot of times. I see people dropping into these confidentiality agreements, 5-year protection clause. Now, certainly companies, that are signing these don't want to sign and have these obligations indefinitely. And then you have issues of whether stuff is maintained on their servers and whether they're physically maintaining documents and all of that stuff. But they, put themselves in the other party's shoes, and they would want presumably the same protections. So, you can always have provisions where they are required to return documents. And if it's not practical to return documents, like, for example, if things are electronic and, of course, they've proliferated onto backup servers and all of that stuff, that they would be maintaining those in the same ordinary course that they were maintaining their own confidential information. Again, that's really generally the level of protection anyway, where they're going to be maintaining that information just as if it were their own. So this is something that I want to highlight because it's a very confusing area for a lot of companies and entrepreneurs who want to do business with other people. They may crib a form NDA off of the web, and it may have a 2 or a 5 or a 7-year clause. And, you have to really think through that. Is that going to be right for your business, depending on the information that you're sharing? Now, maybe it's for whatever particular thing you're sharing. Maybe it's a plan that actually is going to be implemented. And so therefore it's, if it becomes public later, or it's something that you are just exploring and it may or may not be implemented, but if it's going to be implemented, it's going to be implemented right away. Again, these are things you have to consider, and you have to talk to your attorney about that. So the Campbell firm is a general practice law firm. We have a very active business and entrepreneurship practice, for example. And I highly, highly, highly recommend that you speak to your own attorney, or certainly if you want to contact the law firm here, you can contact us, and we'd be happy to have a courtesy discussion with you. We practice in the state of New York. Attorneys here are currently licensed in New York and the District of Columbia, and we hope that you will consider this as sort of a guide to exploring the importance of confidentiality and to exploring with your counsel what's going to be best for you and creating potentially different forms for different situations. We will discuss in another topic confidentiality as it relates to independent contractors and employees. And we hope that you have enjoyed this issue of spotting the issue, or spot the issues, sorry. And again, Emily Campbell from the Campbell Firm. Thank you for tuning in, and I hope to see you again soon. Thank you.